Mhm.
Morning, Judge. How you doing?
Good morning. Morning, sir. Court will begin with the March 3rd, 2023 docket. We're on YouTube, and good morning, everyone. We're here on CL 21-2790D, Benito Rios versus Joaquin Alfaro, DBA, JDA Welding and Fabrication. Yes, sir, Mr. Hernandez.
Yes, Judge. Jose Hernandez here on behalf of the plaintiff, Benito Rios, Judge. The other person on the line, Judge, is my court assistant, just in case we had to present exhibits. I'm on the road going to a funeral in Corpus, so I just pulled over to the side.
Okay.
So,
okay.
But this one, Judge, it's a motion for final summary judgment. There was no response. He did make an appearance the last time it was set, but I was stuck in a court in Cameron County. I didn't get back in time. So, but like I said, there is no response. You know, he had official notice of the hearing, and so therefore a summary judgment is proper in this case with no response.
Okay, court will take judicial notice of the entire file.
He's here.
Wait a minute. I think somebody just logged in. Let's see who it is.
Sure, Judge.
With that cost number.
Mr. Joaquin.
Is a motion for summary judgment against the individual himself or both?
It's him as an individual, Judge, but he has a business called the
DBA.
Welding and Fabrication Company. It's a DBA, so it's
DBA.
really him individually.
All right, there you go. Okay. Okay, he's connecting.
Okay.
There is no video. I don't know if you can hear me. No video. Can you hear me? Any audio? Is this a sworn account, Mr. Hernandez? What kind of a case is this?
No, this is just simply, it was they contracted and paid a down payment on a wrought iron fence for their home in Peñitas, and they paid him half, but he never did anything. It's already almost 2 years old.
Okay.
So he's never done anything. They filed a police report, but the police, of course, told him it's a civil matter. So
yes. Okay.
they had to file the lawsuit, Judge. So that's what it is.
All right. He's still connecting and all that kind of stuff. And but as far as you know, there's no answer on file, right, sir?
There is no answer on file, Judge. He did make an appearance
Okay.
in the case, so that's why we moved for the summary judgment and not the default. And so, but yeah, he did not file a response to it as required
Okay.
by Rule 166B.
And when was the MSJ filed? Do you have any?
The
Any
MSJ
date?
was filed. Yeah, I'll let you know right now, Judge. It was filed on November 17th of 2021.
November 17, 2021. Okay. All right, he's not going to connect. Court will take judicial notice of the entire file in CL 21-2790D.
It's gonna,
Can you hear me, Mr. Alfaro?
he needs to unmute.
You need to unmute.
There should be a microphone.
Aquí estoy.
All right, can you hear me now?
¿Sí escuchas?
Sí, sí, escucho y ahora sí.
Yes,
Okay,
I can
good
hear
morning. Welcome to County Court Law number 4.
You. Buenos días. Bienvenido a la corte
Bueno,
número 4.
buenos días, sí, disculpe, es que no podía componer el audio, pero ya
Yes,
pude.
good morning. Please forgive me, I couldn't connect.
Okay, no problem,
Sí,
sir.
no hay problema, señor.
In this case, Benito Rios versus Joaquin Alfaro, DBA, JDA Welding and Fabrication. There's a motion for summary judgment that has been filed since November 17, 2021 by the opposing counsel, by the Rios party, and there's no
Oh.
response on file. You did
Sí.
not respond to it. Is that correct, sir?
En este caso, Benito Ríos contra Joaquín Alfaro, haciendo negocio como JDA Welding and Fabrication. Hay una moción que Benito Ríos archivó el día 17 de noviembre del 2021, donde esa moción requiere una respuesta de ti y esa respuesta no fue archivada por ti. ¿Comprendes eso?
You need to unmute.
Necesitas poner sonido. ¿Sí comprendes?
Ese tantito. Sí,
Okay. All right.
Yes.
So that's
perdón,
what we're
perdón,
here.
es que se cortó el audio de ustedes. Perdón.
Es que lo que pasa es de que Benito Ríos archivó una moción de resumen. Esa fue archivada el día 17 de noviembre del 2021. Esa
Así es.
moción requiere de que tú, Joaquín Alfaro, archive una respuesta.
Sí. Oh,
Esa respuesta no fue archivada por ti, como requiere la ley.
ok. Es
So, lo
tengo
que
un
pasa,
problema con el audio.
lo que pasa es de que como no archivaste
Ok.
tú la respuesta, entonces el juez tiene que conceder lo que el abogado está pidiendo porque tú no
Ujú.
archivaste la respuesta.
Ok, la carta, es que yo llevé una carta de una respuesta, contestación mía que hice yo, ¿verdad? Pero de carta moción, eso me faltó, fue lo que me dijeron cuando, la primera vez que fui a corte, que fue el
Yes, I think
día.
what happened is I filed a letter, but that's all. Maybe I forgot or I did not.
Well, it was probably like the original answer or something.
Eso que archivaste tal vez es la respuesta
Sí.
original, pero esto es una respuesta a esa moción. No tiene nada que ver con la respuesta original.
Ok, sí, sé lo que me está diciendo, oiga, pero yo no estaba al tanto de eso y pues no lo hice.
Yes, I know what you're telling me, but I wasn't aware of that, so I didn't do it.
And you don't have an attorney, right, sir?
Y no tienes abogado, ¿verdad?
No tengo,
No.
entonces, pues yo desconozco, ¿sí me entiende la situación y qué es lo que tengo que hacer? Yo nomás me quería estoy presentándome, ¿verdad? Pues para hacer arreglo, lo que se tenga que hacer, ¿verdad? Yo tengo que arreglar esta situación, ¿verdad? Yo necesito.
Yes, I'm here.
Eso.
I presented myself and we need to fix this matter and I want to see how we can fix this matter
Or settle it?
or settle.
Okay. Well, what's going to happen is it's going to be a judgment against you today. And then with that copy of that judgment, you can still try to work it out with the plaintiff.
Lo que va a pasar aquí esta mañana, señor, es que el juez va a conceder lo que el abogado está pidiendo. El juez va a firmar una orden, ese va a ser un juicio. Ya después de que él firme esa orden, entonces tú puedes llegar a un acuerdo con ellos, a tratar de arreglar algo.
Ok, a ver, permítame, es que me permite, perdón que le interrumpa. Entonces, ahorita, después de esto, van a firmar una orden, ¿verdad? Pero yo necesito agarrar un abogado o qué ocupo hacer porque la verdad, pues sí desconozco. Pues yo nunca he estado en esa
And
situación.
then, what do I need to do? There's going to be an order, and then what do I need to do? Do I need
Well,
to
what you
hire a
need to
lawyer?
do is contact the other people and see how you can settle it, or there'll be a judgment against you that'll be filed in county clerk.
Lo que tiene que hacer, señor, es hablar con las personas que lo están demandando y tratar de llegar a un acuerdo, porque después de que el juez firme este juicio o esta orden, entonces eso se va a archivar ahí en el condado y ahí va a quedar sellado que usted debe esa cantidad.
Sí, y yo, sí, de hecho, le digo, pasar una cosa tras otra, pero ahorita ya ando en eso, o sea, yo estoy en la mejor disposición de regresar ese dinero, vaya, pues, me fue mal con el negocio, se me cayó.
Okay.
Pero
Yes, I
en ningún
understand.
momento-
Ahorita,
Okay.
porque tengo que traducirlo.
Okay.
It's just the business was not good.
But you're doing better now, he says.
He says he's doing better.
Okay. Mr. Hernandez, what is the amount that is being prayed for or the remedy you're looking for?
Sure, Judge. The actual damages in this case are part of the order of summary judgment are $2,250, the money that was given to him as a deposit for the work.
Right.
There is a space for prejudgment interest, Judge, which I calculated at 5%, which is lower than the rate for today, is $112.50, Judge. The attorney fees of having all the communication, trying to do the letters and filing the lawsuit is $1,500 as attorney fees, Judge. And the case expenses are $500 with the filing fee, the service, and the additional fees, Judge. And then the total judgment amount is, when you add those up, is $4,362.50, Judge. And the post-judgment interest rate, since there is no other, the only percentage we have is the 5% that's allowed by the state of Texas, Judge, at this point.
So the judgment you're looking at, Mr. Alfaro, is $4,362. I mean, sorry, $4,362. And what's going to happen is in that judgment, it's included attorney's fees and court costs. What you can do is, when you get that judgment, is continue communicating with the plaintiff and see if you can settle it.
Señor Alfaro, lo que va a pasar es que ellos están pidiendo los 2,250 que fue el pago que le dieron. Están pidiendo $112.50 de interés, $1,500 de los gastos del abogado que ellos tuvieron que ocupar y $500 de los costos de corte. La cantidad que ellos están pidiendo es $4,362.50. Lo que va a pasar es que el juez va a conceder ese juicio que ellos están pidiendo y va a haber esa orden. Y lo que usted tiene que hacer, si es posible, es hablar con ellos, a ver si pueden llegar a un acuerdo y arreglarlo. Pero esa orden él tiene que concederla, porque es por ley, porque no hubo respuesta que fue archivada por usted.
Ok. Es por ley.
Yes, sir.
Entonces, pero esto que me está diciendo que tengo que pagar, ¿cómo se? ¿Yo me arreglo con quién? ¿Con el abogado? ¿Hablaría con el abogado de ellos?
We're going to get you a phone number.
Sí, ¿tiene algo para anotar el número del abogado de ellos?
Sí, yo tengo aquí algo. Sí, dígame.
Mr. Hernandez.
Sí.
956-603-2058.
And that's 956-603-2058. 956-603-2058. Y el abogado se llama José Hernández. Trate de comunicarse con él para que pueda llegar a un acuerdo, señor.
Okay.
No, se cortó el audio.
Sí, trate de comunicarse con él para que puedan arreglar algo, pero ahorita el juez va a conceder esa orden que están pidiendo.
Ok.
Bueno,
está bien, entonces yo me comunico con él.
Thank you. I will communicate with him. Sí, gracias. Is that it?
Gracias.
Yes.
Court will take judicial notice in the entire file, Benito Rios versus Joaquin Alfaro, DBA, JDA, Welding and Fabrication, in cause number CL 212790D. Court will hereby grant plaintiff's motion for summary judgment. Court will grant plaintiff all relief requested here in its motion, and court will sign a default judgment. An order or judgment later today.
Thank you, Judge. I have nothing further. Can I be excused?
You may be excused. Thank you very much, sir.
Thank you, Judge. Be safe. Have a good day.
You too. Bye. All right, let's see here. Court will now continue with the March 3rd, 2023 docket. I have F1607-17-4 in the matter of the marriage of Treviño. Good morning, Mr. Garcia.
Good morning, Judge. How are you this morning?
Fine, thank you, sir. Good morning, Mr. Hinojosa.
Judge, good morning, Judge. My client is Eric Treviño. I guess he's basically, I don't know if he connected in or not, but
I think he's
It's right here, but there's no audio.
Oh, yeah, he's there.
There's an Eric's iPhone. I don't know if that's it.
yes, that's him.
that's probably him.
He's trying to click
Okay,
on.
he's connected. What's the deal here, guys?
Judge, if I may, it's my motion for judgment num pro tunc, filed on January 12th, 2002. And the issue on the num pro tunc, Your Honor, is that there is a quadro, a qualified domestic relations order that was filed on April 21st, 2021, regarding a 403B plan that under Diana Treviño. And in the quadro, my client is basically the alternate payee, and he's awarded 40% from the participant's vested account balance as of August 28, 2019.
August 28, 2019. Okay.
Judge, that number 40% is incorrect. It should be 50%. And let me explain why.
Mhm.
In our motion for judgment non-pro-tunc, Your Honor, we have included as exhibits the final decree of divorce, which was heard on August 28th, 2019. And we have also the mediated settlement agreement in this case, which was, let me give that, Judge, let me get the date on that. The mediated settlement agreement on that case is from May 23rd, 2019. I'll first go with the mediated settlement agreement. In that mediated settlement agreement, all the parties signed off where my client is awarded, and this is on line 12 of the mediated settlement agreement, which is marked as Exhibit 2 to the motion for judgment non-pro-tunc.
Mhm.
Dad shall be awarded 50% of her 403B account. So Dad, of course, is Eric Trevino, and her account, of course, is Diana, at that time, Diana Trevino, now Diana Sandoval. So he is awarded 50%. Right above that, on number 11, there's another quadro that we had to do, and Dad was awarded 41.5%, which was done, signed, so that's out of the way. But by mistake, when we did the quadro, Judge, we put 40% instead of 50.
Mhm.
The divorce decree, Judge, where that was rendered on August 28, 2019, on page 24 of the divorce decree. Let me get page 24, which is Exhibit 1 to the judgment non-pro-tunc motion. On page 24, on the property division, it indicates, here we go. Let me get that. I apologize, Judge. 24, here it is. On R6, 50%. Eric Trevino, who is basically responded with R, he is awarded 50% of petitioner's private 403B annuity. Petitioner in the divorce is Diana Trevino. And right above R5, of course, is right above R6 is R4, which basically has the 41.5%. So it was a mistake, Judge, that we did a quadro that had 40%. It should have been 40. It should have been 50% of the 403B plan. So the mediated agreement has 50% 403B plan. The divorce decree has 50% of the 403B plan. And also the divorce decree indicates that it is basically finding that there is a mediated agreement that has been merged with the divorce. So when everything was rendered at the time of the divorce, Judge, it was 50% of the 403B plan. The quadro in question, Your Honor, the quadro in question, which was basically filed and was prepared by my office. I'm not saying it wasn't, it was prepared by my office. It was basically a mistake. It was a clerical error, Judge, that was done. Now, the question is whether, well, can the court basically change the quadro? Can the court basically do anything with the quadro, Judge? With that, we look at basically Texas Rules of Procedure. We look at 316. And Judge, basically Texas Rules of Procedure, Rule 316, correction of clerical mistake in judgment record. Clerical mistakes in the record of any judgment may be corrected by the judge in open court according to the truth or justice of the case after notice of the motion thereof has been given to the parties of interest. And therefore its execution shall conform to the judgment as amended, Judge. So 316 says, you know, you can do a non-pro-tunc at any time if the court finds there is a clerical error. Now, I understand, Judge, that basically the court, you know, the order has been signed. We didn't discover this till months afterwards, but it is a clerical error. So the court still has authority to basically do the non-pro-tunc. Also, Judge, statutory, we look at 9.007, limitations of power of court to enforce. A court may not amend, modify, alter, or change the division of property made or approved in the decree of divorce. Judge, the decree of divorce has 50% 403B. The quadro, what was signed by the court, basically says 40% of the 403B. So what the quadro does, it modifies, it alters the property division. The court cannot basically modify a property division through a quadro. And Judge, that is 9.007 of the Texas Family Code. Now we look at what authority is there under case law, Judge. There are several cases that address this point specifically. There is a case, Your Honor. It is basically called Gaines versus Gaines. Let me spell it because it's Gainous versus Gaines, Gainous, 219 Southwest 3rd, 97. It's out of the Houston 1st District, and it's a Court of Appeals case, and it deals with a quadro. And it indicates a quadro and a non pro tunc. It indicates, Judge, if I may, a quadro is a species of post-divorce enforcement or clarification order. A court may not amend, modify, alter, or change the division of property made or approved in the decree of divorce. At this time, this is a district court case. It says the district court was therefore without authority to enter a quadro, altering the terms of the decree by limiting the former wife to an interest less than awarded in the divorce. And Judge, this court basically also specifies, it looks at 9.007, limitation power of court to enforce. So what this case indicates, Your Honor, is that there was a divorce decree already done. It had a property division. In here, the parties made an error in the quadro. It altered the property division by mistake in the quadro. So what the court here says, you know what? You look at the final decree of divorce. A quadro is only a tool, secretly a tool to enforce property division. So the quadro is basically a tool to enforce the division of the retirement. That's what a quadro is. So you look at the decree of divorce. The decree of divorce basically says 50% 403B. So it is a clerical error, Judge, here, because at the rendering of the divorce, it said 50%. The judgment says 50%. Quadro says 40, but a quadro cannot change the property division under this Court of Appeals case, Judge, that I just stated. Then I go, well, let me see if there's any other court case. And Judge, there is basically 2 Texas Supreme Court cases which follow this. You have a Texas Supreme Court case called Shanks versus Treadway, 110 Southwest 3rd, 444. It's a Texas Supreme Court case, and it deals with a action out of Dallas, Judge. And here it goes. It basically says the same thing. The court may not amend, modify, alter, or change the division of property made or approved in the decree of divorce. This also deals with a quadro, Judge. But what this case goes further, the Supreme Court goes further here and says, the court was therefore without any authority to enter a quadro, altering the terms of the decree by limiting this person here, her name was Kendra, to 25% interest in the benefits. See, again, this case here, Supreme Court deals with a percentage of benefits, Judge. And Judge, so it says you can't alter what was already rendered. So the quadro cannot. So this is a Texas Supreme Court case says, you know what? You can't, the quadro is not base controlling. You look at the decree of divorce. Then I go, well, there has to be something further. There is, Judge. There's another Supreme Court case, which is Dalton versus Dalton. And this is basically out of Houston, Your Honor, if I may. And it is 551 Southwest 3rd, 126. Dalton goes further, Judge. Dalton deals with the quadro also. It cites the previous cases. But what Dalton goes further, you know what? If you got a quadro that modifies or changes the property division, that quadro is void. It goes further to indicate any quadro that alters the decree's property division is void. So, Judge, what we have here, we got a decree, we got a quadro. It's an error. It's a mistake. There's no question about it, Judge. We went before this court at the time, read it into the record, and we said 50% for 03B. Because the quadro says 40%, Judge, it alters the terms of the decree of divorce. It alters the mediated settlement agreement. This court has jurisdiction basically to, I'm going to say one, to do a non-pro-tunc. But if we look at the Supreme Court case of Dalton versus Dalton and the other cases, Judge, that quadro that basically modifies the property division is void, Judge. So we would have to submit a new quadro with a new effect of 50% of the 403B, Judge. And that is my argument, Your Honor.
All right, thank you, sir. Mr. Garcia?
Thank you, Your Honor.
Yes, sir.
Let's start with the non-pro-tunc. The law is right that if it's a clerical error, the court can sign a non-pro-tunc order. The problem is if it's a clerical error of the court. This is not a clerical error by the court. It's an error by someone in Mr. Hinojos' office. So I don't think this would be a non-pro-tunc because we don't have a clerical error of the court. Second point is, as Your Honor knows, since you signed this back in April, you lose your plenary power 30 days after to modify the order. And this would be a substantive modification going from 40 to 50%. So you've lost plenary power to do that. Now, the third matter is, Mr. Hinojosa cites several cases, and that's great. That means that somebody actually filed an appeal within 30 days, and that's why it made it to an appellate court. Well, here, if you sign this in April and it's wrong, then Mr. Hinojosa's office had until 30 days from then to file an appeal or file a motion for new trial or something to get it changed. But here we are, I guess, 11 months later, and so it's way past your plenary power. So I don't believe the court has the authority to change this quadro from 40 to 50%. And it's certainly not a non-pro-tunc order because the clerical error is not on the part of the court. We're talking about an error on the part of one of the litigants, and that does not justify a non-pro-tunc order. So for that reason, I don't think the court has the authority to change it from 40 to 50. Even though the decree does say that, it does say 50% of petitioner's private 403B annuity, which I assume is this one. The error on the part of the litigant does not expand the court's plenary power. Your plenary power expires 30 days after you sign this.
May I respond, Judge?
Yes, sir.
Thank you, Judge. What counsel is not looking at, again, is 3.3 Textual Civil Procedure 316, dealing with basically non-pro-tuncs, Judge. The court basically has authority even beyond its plenary power jurisdiction, as Mr. Garcia says, after the 30 days. It says the court, on a non-pro-tunc, when the clerical error, the court is not bound by that statute, by that section, Judge. Clarification orders cannot be used to make any substantive change. But here, Judge, we have a non-pro-tunc of a clerical error, and the court under 316 can make the change. The cases I cited before the court, Supreme Court cases, are when the court was beyond its plenary powers. That's why they filed non-pro-tuncs, Judge. If they didn't, they would have done motions to clarify. They would have done motions for a new trial. But these cases that I cited, the Supreme Court cases I cited, are when the court has lost its plenary jurisdiction beyond the 30 days. That's why they filed a non-pro-tunc, because they follow Rule 316. Hey, court lost plenary jurisdiction. Let's do 316. That's the only way a court can change it, Judge. You look at 316, you look at 329BF of the Texas Rules of Civil Procedure also, Judge, which basically states the court basically, if it's beyond the plenary jurisdiction, the court can do the non-pro-tunc. Now, counsel says, well, it's an error done by Hinojos' office. Judge, every order that's done, that's clarified, it has non-pro-tunc, is prepared by somebody's office. The court doesn't prepare the actual documents themselves. So for counsel to say, well, Hinojos prepared the order and made the mistake, even though it's clerical, but it's not the court's order. Judge, this is the court's order. The court order basically says 40%, when we all know it's supposed to be 50%. And Judge, I did cite, and I'm just kind of surprised that we're ignoring, if we're going to ignore basically the Texas Supreme Court, which I read the order here regarding quadro, which indicates that the quadro is only a tool to enforce the property division of the divorce decree. That's Dalton versus Dalton. So if the court leaves this quadro alone, it's modifying the property division of the final decree of divorce, which it cannot do. That's Dalton versus Dalton. That's also 9.007 of the Texas Family Code. So Mr. Garcia's arguments are faulty, Judge. They are faulty, Judge, because the court can basically do the non-pro-tunc, or as the Dalton versus Dalton indicates, any quadro that alters the decree's property division is void. Just doesn't matter that my office prepared the order or who office prepared the order. It is a void judgment, Judge, if it modifies or alters a property division. So Mr. Garcia's arguments that he made are not standing, Judge. So I'm asking the court to follow basically the case law that I cited. Also understand that this is a clerical error which the court can change, because I got a mediated agreement. I got the divorce decree that says 50%. Yeah, I got a quadro that says 40%, Judge. It should have been 50%. It's clearly a clerical error, because that 50% was already rendered before the court in the decree of divorce. Thank you, Judge.
Mr. Garcia.
Yeah, just a brief follow-up, Judge. Yeah, anytime a court is alleged to commit error, as Mr. Hinojosa is saying now, there are two options, but you all have to do those options within 30 days. You bring it to the court's attention with a motion for new trial, a motion to reconsider, things like that, within 30 days. Or option two is to appeal. But if you bring it to the court's attention beyond 30 days, even if the court acknowledges, hey, I made a mistake, the court has lost its plenary power. That's the problem here. It's not whether it should be 40 or 50%. It very well may be 50%, and that very well may be right. The problem is a court is without power to change it when it's brought to the court's attention beyond 30 days. That's the problem. None of the case law, none of the rules, none of the statutes that Mr. Hinojosa has mentioned extends the court's plenary power. The only thing that extends it is a motion for new trial, a motion to reconsider. That will extend it, but you got to file that within 30 days, or you have to appeal within 30 days. So that's really the issue, is not whether it should be 40 or 50. That may not be the issue. The issue is whether you have the power today, 11 months after this motion, after this order was filed. And that's the problem, Judge. I don't think you have that power.
Judge, that is clearly incorrect. And I think counsel knows this, Judge, because it's Rule 316, corrections of clerical errors, mistakes in judgment record, Judge. A clerical mistake in the record of any judgment may be corrected by the judge in open court according to the truth or justice of the case after notice of the motion. Now, there's another Supreme Court case out of Starr County, Judge, rear grant that extends from Starr County, called Escobar versus Escobar, 711 Southwest 2nd, 230. After the trial court loses its jurisdiction over a judgment, which Mr. Garcia says the court has, which is true, the court has, it can correct only clerical errors in the judgment by judgment nunc pro tunc. In the regard of trial court has plenty of power to correct a clerical error made in entering final judgment. So, Judge, you have the authority under a clerical error. And Judge, I gave you the case law that says that you have the authority. So the court can, on a clerical error, do it, Judge. But I also indicate, I gave you the case law, if I have a judgment, if I have a quadro that's wrong, and it clearly is wrong, then that quadro cannot modify or alter. So just, I'm repeating myself, and I shouldn't have to repeat myself, because I provided the court statute, case law, everything.
Just one more thing, Judge.
Yes, sir.
Yes, Mr. Hinojosa reads Rule 316 correctly. It does say clerical errors of the court can be corrected. Problem is, this is not a clerical error of the court. That's not what it is. It's an error on the part of the litigant. The rule does not say errors by the litigant can be corrected by the court. Therein lies the problem.
Judge,
The court did not make a clerical error. The
Okay.
motion was sign this quadro with 40%. Here's a proposed order with 40%. You remember I opposed it and the court granted it. It's not what a clerical error is if the court says, I rule A, B, and C, and then the judgment that the court signs doesn't say A, B, and C. That's a clerical error. This is not a clerical error by the court. The court granted exactly what was requested and exactly what was in the proposed order. That is not a clerical error.
Judge, that is incorrect. That is incorrect, clearly incorrect, Your Honor. The court, once a court signs an order, it becomes an order of the court, Judge. It's not my order, it's the court's order. And basically, the Supreme Court indicates you cannot modify a property division, Judge.
Okay, let me go ahead and review the three cases that are here, and then section 316 TRCP.
Do you need me to send the, you need me to send the,
Submit-
you need
No,
me to
just submit. No, submit your proposed orders, please.
All right,
I'll sign something. Hopefully, what's the day? Thursday? Yeah, hopefully by Monday I'll sign something. Proposed orders here, granting and denying your